What is up, guys? Welcome to Truth and Transparency. Happy Monday. Tomorrow kicks off the Karen Reed case. So those of you guys are going to be following the Karen Reed case, it kicks off in the sense that it's jury selection begins. So we will quickly get this over with and say that wishing nothing but the best for Olivia and Steve Jr. if they are together. If they aren't together, I believe that they are together. And I will just say one thing about that, and that is awesome. Everyone deserves to be happy. Everyone deserves to be in love with whoever the hell they want to be in love with. And that's it. There's nothing to talk about. So that's my official statement. So congratulations to Steve and Olivia. I think that's, everybody should be happy. Don't think that should be a focal point of anything. Now, welcome to the main event. Right here, the MPD Daily News. That is the Moscow Pullman Daily News. Well, I want to see if they are going to be covering the breaking news. So I'm calling the chief editor. And when can we expect some? Whoops, let's try this one. There we go.
Hi, this is City Editor Matt Bainey. I'm either away from my desk or out of the office right now. You can leave a message for me at the beep. Thank you.
Record your message at the tone. When you are finished, hang up or press pound for more options.
Hey, what is up there, Matt Bainey? This is Lana with Truth and Transparency YouTube channel. Giving you guys a shout over there. Was curious if you guys are going to be covering the latest in a potential and alleged, I don't know if you want to call, with Miss Jennings and the prosecutor's office, Bill Thompson, Ashley Jennings, and any implications with the prosecutor's office in having a hand in potentially fabricating, manipulating evidence in the Brian Colbert, Idaho versus Brian Colbert case, the Idaho University student murders. If you can give me a call back, I would love to chat with you, see if you guys are going to be covering this for the citizens of Moscow and Pullman. I was trying to see if you guys had been updating anything, but I haven't seen, and this broke on Friday. Today's Monday, so I figured I'd give you guys the weekend. And I'm sure you guys are hot on the tails of Miss Jennings and Bill Thompson to see if you guys can get a comment. But would love to chat with you. Thank you so much. Give me a call when you get a chance. My phone number is long recording. Yep, putting it all out there. Now, next up, MPD. Hot on the tails. Hot on the tails. All right, next up, I want to know if the Moscow Police Department, are they allowed to comment on this? Okay. There is a gag order, but it seems like people aren't abiding by the gag order. So we'll just go ahead and call them up and see if they want to speak. Right? Nobody seems to be, keeping in line with a gag order. So let's just call people up and just ask them what they think. This is some serious allegations. So good afternoon to everybody out there. see. I don't know why I feel like we're having a sleepover and we're pranking people, right? I mean, just a lot of call and ask questions. So next up is the Moscow Police Department. Do they have any comment on what has been going on? Like, are they going to do a press release? By the way, the Moscow Police Department has a 2 out of 5 rating. 2 stars, in case you guys didn't know.
Police and fire dispatch.
Hi, I was wondering. Oh, wait, this is the non-emergency line, right?
Yes, it is.
Okay, good. I was just trying to reach somebody that does public relations for the Moscow Police Department.
Are you trying to make a report or?
No. I just have a question. I'm inquiring as a journalist.
Oh, okay. Let me get you over to their front desk.
Oh, okay, thanks. Sorry.
Moscow Police Department.
Hey, how you doing over there? I was curious if anybody was available in your public relations department. Do you guys have anybody that's doing like for journalists that call in?
That usually goes through our chief since he was the public affairs officer.
Oh,
For a
Dollinger?
little bit of time. I can. Yep.
Okay, cool,
Yeah.
cool. Yeah.
I can get you up to his assistant. Just one second. You have reached the desk of Karen Potter. I am either in a meeting or away from my desk. Please leave your name and phone number, and I will call you when I am available. Thank you for calling.
Hi, Carol. It is Lana with Truth and Transparency. I'm actually calling as a journalist and wanted to see if I could speak with the captain, the chief. Now, in regards to the latest, I know that there's a gag order in the University of Idaho student murders, or what I believe there to be a gag order, but was curious if you guys have any statements on the latest accusations, allegations pertaining to the prosecutor's office. And I was just wondering also the protocol with does that conflict the Moscow Police Department out from actually looking into these allegations, because it has to do with the Idaho student murders. And so I just had a lot of questions. And I'd rather just come straight to the source, get the information. And, even if you can't give a statement, if you could talk about the protocols with, would you guys even be able to investigate into allegations against your prosecutors? So I would love a call back at your earliest convenience. All right. Good afternoon. Next is the student newspaper. The student newspaper should be all over this, right? The Argonaut, that's it. the Argonaut for, of, and by the students since 1898. What do we got here? The Argonaut. Give me that contact number. Contact staff now. There we go. Connor Anderson. Nope. Editor-in-chief. Maybe. We ain't got no phone numbers. We're just gonna have to call the school. We're just gonna have to call the school. All right, University of Idaho. Here we go. Admissions. There we go. What a day. I feel like I'm calling Brandon Walsh from the 90210, the student paper. This is Andrea Zuckerman with the student paper. This is Brandon Walsh with the student paper.
We are sorry we missed your call.
Fucking bet you are.
Please leave your name, number, and question, and we will get back to you as soon as possible.
I mean, what is this?
Please leave a message after the tone. When you have finished, please hang up.
Hello, yes, I was wondering if I can get a call back. I'm trying to reach the Argonaut, the school paper there since 1898, bringing it home for and with the students. A fellow journalist here trying to reach out to your correspondents over there at the Argonaut, trying to find a number to reach the school paper. If I can get a phone call back again. What the fuck? All right, next up. AT&T. The fuck? Okay, here we go.
You have reached AT&T Global Legal Demand Center and the Asset Protection Client Services After Hours Response Center. All calls are monitored and recorded for quality purposes. If you're calling from a 911 emergency center or if this is a life or death emergency, press 4. If you are calling from an Asset Protection Client Services matter, press 8. Para cumplir su llamada en español, presione 6. There are more options, but please note that the preferred method of service is by email at gldc@atsprotection.com. at att.com. The fax number is 888-938-4715. And the mailing address is 11760 U.S. Highway 1, Suite 300, North Palm Beach, Florida, 33408. Our registered agent for civil subpoenas can be found by going to the local state legislative website. Please ensure you check your spam folder or email for responses from glbc@att.com or comsent@att.com. Most requests for status update are resolved by doing these actions. If you have already checked your spam email and searched for responses from our email addresses, choose from the following options. For search warrants, press 1. For career-related court orders, career trouble tickets, press 2. For customers not working directly with an attorney or law enforcement, please hang up and call customer service at 1-800-331-0500 or 611 from your cell phone. To speak to an AT&T Global Legal Demand Center analyst regarding subpoenas or court appearances, press 5. If you stay on the line, this entire message will repeat. Thank you.
All right.
You have reached AT&T Global Legal Demand Center and the Asset Protection Client Services After Hours Response Center. All calls are monitored and recorded for quality purposes. If you're calling from a 911 emergency...
Okay, hold on one second.
Welcome to AT&T. Just so you know, calls are recorded for quality and the purposes stated in our privacy notice. Para español, oprima el ocho. Please say what you are calling about.
Search warrant policy.
Sorry. What can I do for you?
Can I have an agent, an operator?
Sorry. Without more information, you may reach the wrong agent, increasing your hold time. What is the reason for your call today?
Policies on search warrant.
Sorry, can you rephrase?
Policies on criminal search warrants.
Sorry, please say what you need help with again.
Policy questions.
Please wait. One moment, please, while I handle your request.
We're going to go this way first. Just say stop.
All of our representatives are assisting other callers. Rather than have you wait on hold, we can call you back when it's your turn. Between 16 minutes and 24 minutes from now. You will not lose your place in line if you choose to use this service. With a callback, you also receive the benefit of text message updates.
Perfect.
To receive a callback as soon as possible, press 1. To decline and hold. I'm sorry, your response was invalid.
What?
Please try again. I have your phone number.
There you go.
Please say your full name at the tone.
I don't need to. Just call me back. All right, we're hitting off all the different ways to do it before we just go straight legal. You never know what a young buck might tell you. Might send you. Carol. Okay, now. Oh, hi, it's AT&T. Hi, AT&T. What you got for me? Hi, it's AT&T. Thanks for requesting a call back. We'll call you back in about 24 minutes. We look forward to speaking with you soon. I bet you do. And I want this all in Spanish. So, again, good afternoon. We are inquiring some things this afternoon. So far, we've called the Moscow Police Department, the Daily News, the Argonaut, well, the school, but I sent off a couple of those emails. Again, now Carol Wells. I have a couple questions about Carol Wells. See if she has any comments to the latest.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I did, I think, one concurring opinion in a case
I
that
call
held
him.
otherwise.
What's up, girl?
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about. Our first point is it was an illegal search. And this is if
Search,
the
which
court's
search?
assumption.
Which search? It was illegal.
Well, first the snippet Othram, then the snippet the FBI,
Snippy.
and then the trash pool.
You're talking about the
Snips.
Do we think
that
Snippies.
maybe has some integrity issues? A judge is not going to sign off on that. And then if you say, but to support that, I built this false look at a whole investigation here. I'm going to tell you these other things that I know that I had no idea about before my confidential informant was here. And these things don't add up anyway. There is not, in my view, a judge that's going to find probable cause because somebody got stopped by law enforcement. I think it was a seatbelt ticket months before.
the purpose of the submission of that was simply to identify the car that he drove and the fact it didn't have a license plate on the front.
No, it wasn't.
It wasn't to suggest it's otherwise connected to the homicide, except to say this is a car of interest and the defendant was found driving it.
Well, let's talk about that license plate for a second, though, because that's not something you can see from the videos. And that was testimony you heard today. You can't see that from the video that the cops relied on here. So that bit about the license plate, that's something a little bit extra that happened after we have this IGG stuff. That wasn't known before. There was no video collected from WSU before. There was no communication with the officers at WSU before. So before the identification through IGG.
I'm just not tracking why that matters. Go ahead.
Oh my God, I'm just not tracking why that matters. You have to always go back to the beginning, guys, as we sit here and wait so patiently. I wanted to play all that again. It's just, I'm not tracking why any of that matters. Well, we just found out there was no videos that were turned over by WSU to the investigators until after December 19th. It was December 20th.
It matters because this wasn't a real investigation. These are things that are put in there to make it look like an investigation happened, to say, don't look here at this big glaring thing that's missing, this whole piece about why we identified him. Don't look here. We don't want you to look here because this is ugly, this is dirty, and this isn't real. That's precisely why those things are placed in that PC affidavit like that. So based on that, the first warrant gets issued. It doesn't end there. This warrant is not good. There's too much missing information, false information, and information withheld from the magistrate here. But then the warrants just rely on one another. There are other things to add into later warrants as well. And so I want to go through some of those other things with you. I do want to comment.
God, Hitler's got to be like just rolling right now. Like, everything they said is not true.
On the affidavits being used by a variety of officers, I understand the collective knowledge doctrine, but that's not what is going on here. You have an affidavit that sometimes Moscow police attribute it to the person that really wrote it, but quite often it's just the name taken off, and who claims to have done the work is whoever signed the bottom of it, and it can't be the same. So it's not quite the same thing, and that matters as well. But let's talk about the second warrant. The second warrant is also AT&T. The first one comes in, and an hour later, they say they have all this data analyzed, and they say they now need 6 months worth of phone records for Brian Koberger's phone. They do acknowledge that his phone wasn't contained within the geofence when they looked at the geofence. But this second warrant is important, and we're going to talk about minutes difference of time. In the first AT&T warrant, in that affidavit, the police officer talks about 2:42 a.m. that WSU cameras, because they start looking at WSU cameras after the IGG identification, they find a white car that they say is an Elantra at 2:42. So they get the phone records, and then it becomes 2:44 that they say Mr. Koberger's leaving his residence, 2:44 a.m. And the place near Bishop Boulevard where one could turn to go to Moscow at 2:42 is inconsistent with 2:44, but they don't correct that. They don't say that vehicle at 2:42 cannot have been the right white Elantra running around that night, because we now know it was at 2:44 a.m.
You understand that you just can't make up a vehicle. You cannot just make up a time. like it's either seen on the cameras or it's not. Okay.
They want to keep that in there because they want the car positioned like it's going to be going to Moscow. And that is really important with the misleading of the magistrate. When you look at 1A, that's the map we looked at earlier today, where there's the whole loop around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the phone stops reporting to the network at 2:47 a.m. And that's not right. We submitted their cell experts report that say the phone stops reporting at 2:54 a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records, and that's just not right. Don't get caught up in thinking 7 minutes don't matter here. We're talking about ground that can be covered in a vehicle in a short time. We're talking about 2 towns that are fairly close together. And so the way a car points when they go off the network matters a whole lot in this circumstance. That's not corrected in any of the affidavits.
Is that right?
That's the part that's really exculpatory to Mr. Koberger, is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going. The FBI knows how to do this. They chose not to do this. They chose to take a time 7 minutes before it really stopped reporting. And they chose to make a map that showed a direction that phone wasn't traveling in, to create a false narrative for the magistrate to rely on to find probable cause.
Because they didn't use IGG.
You're all I draw the court's attention to D7 and 8. Those are the affidavits from the defense experts. Their CVs are in D28. Once the second AT&T warrant comes, then you end up with warrants for Mr. Koberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Koberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C. That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records. But based on those records, they absolutely knew that Mr. Koberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IGG identification off to the side. But then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking, because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the cast draft report and in the cast final report, because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Koberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. We'll move forward to the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Koberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to the people in the house. Your Honor, I'm
Maybe I'm thinking of a different date for the AT&T not the cell tower stuff. So you're still talking about the cell tower stuff?
No, I mean, that stuff applies to every single warrant we have because that was
I thought
early.
you transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about
Is in the car.
Other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in itself probable cause to support any of it from there?
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Koberger's car and the lack of DNA in his apartment, the lack of connection to the individuals.
What is that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA in the sheath and Mr. Koberger.
Mm-hmm. Yes, from IGG.
Isn't that probable cause every day and twice on
But they
Sunday?
didn't use.
Not in this context. Not in this context because of the IGG work. Because I mean, that's the ultimate question that will be before a jury. What does that mean?
Yes,
right?
but now it's going to be out.
A knife sheath at a scene mean?
I
That's
think
gonna be
the
ultimate
sheath's
question.
out.
You're
Killed by a knife, it probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. It's probable cause to think that this person might have done it.
Off of what?
And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think.
Oh,
That there's a lot of pause, even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about. Let's just go with the car. Let's just go with.
I understand the lack of evidence of DNA material or other victim-related material in the car and in his apartment, as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that might be the case. And when a magistrate's looking at this, they have a direct DNA match to a person from a object likely associated with a murder weapon. I've not yet met a magistrate would not find that probable cause.
If the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say. There's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, they told the magistrate about that this is the video, this is what matters. It parks at this certain time, it leaves at this certain time. if you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked. There's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Koberger, and it matters a whole lot.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence. When there are other things in the affidavit or affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits. I guess, and I don't intend to argue with you about it. I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA, it seems to me that it's an uphill battle to say there's not probable cause at that point.
This is what told Ann Taylor how she would play the rest of the cards. Because without IGG and using that process, there is no Brian Koberger. So if you can't talk about that at all in this trial, okay, and you can't talk about what evidence did you link Brian Koberger to, and like any of the process, how are you going to be able to talk about the sheath?
Well, Your Honor should never get to that question, but I'm going to answer it for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they just build on each other. So
there is exactly.
You find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question.
She's saying you don't get the DNA, Bowie. You don't get that. You don't even get to sniff having Brian Koberger's DNA by swabbing it after the arrest, because probable search warrant 1 and search warrant 2 with the AT&T and word saying that this car and phone are going is a lie from fucking Ashley Jennings, and that's where we're at right here. So, but this is exactly how you have to do it, though, to show. Yeah, exactly. So they used IGG to develop probable cause, because you don't have anything to go and why would you ever go and pull trash from some fucking dude in Pennsylvania? Check this out. Share. Zoop, zoop. Working on a piece over here for my show with Bob. Okay. From the did it share there? Okay. As such, did you participate? This is Payne being asked this question. Yep. And when was the first time you heard Brian Koberger's name? The first time I heard Brian Koberger's name was December 19th. And what was that a result of? That was a result of investigative genetic genealogy that was being undertaken by the FBI. We had a phone call that evening, and we were told Brian Koberger's name. And before that, Mr. Koberger was not on your radar. No, ma'am. Before December 19th, was the FBI cast team members co-located with you? Yes, ma'am. How long have they been So, next.
There. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more.
Well, I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
Okay. I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway because you brought up blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Koberg? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
Earlier event? What happened in the house earlier?
What the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them,
blood
matter. What's the other explanation? What's going on with this investigation?
Clamps.
What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know that Brian's car and the court's question, good question. What does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Brian because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
But you don't get it with that information. You don't ever get the swiping of him because you don't get the arrest. But Anne is smart. She's like, I'm not going to argue certain things right now because I just need Hitler on the record. Keep on talking. And he made his point with 30 some pages.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
Woo! Criminal justice system.
Which is, even if you add that stuff, does that take away probable cause, counsel? And my problem is once you have a direct DNA tie to the defendant, for purposes of probable cause,
See,
isn't for purposes of conviction.
purposes of probable
For
cause.
purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts.
That she was lied to?
As to Mr. Koberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further. But I'm not sure that that diminishes the probable cause as to Mr. Koberger if his DNA is found on a knife she found on or near the victim who was stabbed with said alleged knife that would have been in said alleged sheath.
I think the most prominent question is, how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause. because there are more questions than there are answers. And all of a sudden, this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were.
Okay, so then when she's asking Payne these questions right here, so let's talk about this IGG. Did you have any role in deciding to pursue investigative genealogy? Yes, ma'am. It was a collaborative decision amongst the command team to go that route. But yes, I was part of that. Were you part of the discussions during the process of the identification? Yes, ma'am. Were you aware that Othram Laboratories began the work on the investigative genealogy? Do you see yes, ma'am? Boom, we just wiped out Othram now, IGG. What kind of information did you receive from Othram Laboratories? I don't remember what we received from the Othram directly. I knew that they were conducting their specific type of work. I don't remember exactly what they provided us with. Did you receive some documents from them? Yes, ma'am. Okay, do you know how many you received? I do not. Was it a one-time thing? I don't remember. Were you part of the discussions to take the work from Othram and go to the FBI? Yes, ma'am. Why was that decision made? This is all about the sheath, the DNA, and the IgG all together. Okay. Why was that decision made? From my understanding, granted, this is my first encounter with investigative genealogy. So again, as a collaborative discussion, we decided that because the Idaho State Police Lab and Othram had essentially exhausted their resources. Okay, because they had exhausted their resources. This is how I understood it, that we would move to the FBI for the IgG. Now, what have you just done? Taken out the FBI to be able to talk about a tip, a generic tip. The FBI, do you know what more resources the FBI had? The only thing I'm privy to was that they had more databases. Yeah, illegal ones, right? Ones that you were not supposed to use, right? How did you communicate? So our communications were just via telephone. The sample was sent to the FBI. The IgG SNP. Okay. You are wiping out all of this. Ann Taylor is one smart motherfucking woman, man. Smart. If they're gonna lie about something, how do you beat liars? Well, okay. How did Judge Hippler determine, after he believed that Payne was testified credibly, how does he determine that they came to Brian Kober's name prior to December 19th by WSU? How does he even write that in an order? Okay, so then check this out. Then I don't remember the date it was given over to them, but after that, there was very few conversations. And if they happened at all, they were just, telephonic advising us that the process was still in the works and they would let us know when or if they had anything of interest for us. Do you know what files or documents went to the FBI from Othram? I do not remember. Did you receive documents from the FBI in relation to IgG? Yes. I believe after the fact, after we received Brian Koberger's name, we did receive documents, but I don't remember what they were. Do you know what the documents related? Oh, wait, hold on. Did it clip the part that talks about the tree? Did I say that part? Okay, so she comes back to it right here. Okay. Did you know how many documents related to IgG? No, ma'am. I believe as part of the discovery, it was in the thousands. They didn't receive shit, the defense. Oh, and she's like, thank you for that. The reason she says thank you for that right here, thank you for that. And I knew it. I was like, she just, whoop. All right. So once you have Mr. Koberger identified, what's your understanding of what that meant to have his name? Just in relation to the overall investigation, is that yes. Ready? So the only thing that was given to us was Brian Kober's name. That was it. It was conveyed to us by the FBI, who Payne knew was working on the IGG, okay? Because he knew that Othram had sent it over to the feds, that it was to be taken as no more than a tip. That was it. So once we received his name from the FBI from IGG, so again, this is out. We set about doing basically an independent verification of whether or not he was involved in this crime. And she's like, I'm going to talk to you about that a little bit more, but do you know why the FBI connected Brian Kober to the case? Ann Taylor is trying to get him specifically to say the motherfucking sheath. She is specifically trying to get him to say the sheath. If she can get him to say the sheath, we're connecting the IGG to the sheath. Okay? You understand where she's going with this? Because now we can look back at it. Is at first we're like, why is she asking these questions? What the fuck is she doing? Oh, it makes perfect sense now. So she says, but do you know why the FBI connected Brian Kober to this case? So December 20th, here it is. If memory serves, we had a secondary meeting with the FBI via Teams. If memory serves, and they simply walked us through the family tree. So remember, everything to do with IGG, family tree, it's all going, okay? How they did that. Now, I don't remember the details of all that, but it was in-depth conversation. To be honest, it's above my head. But essentially, they worked their way through the family tree and arrived at a conclusion that Brian Kober was a person we should look into as a tip. That's the extent of my knowledge of how they did that. How was Brian Kober, the name you received as a tip, linked to this case? Again, Ann Taylor's like, come on, man, give it to me. He wasn't until after December 19th. Boom! And then, what item of evidence did you link Brian Kober to? I'm not sure what you're asking. As far as like before December 19th, is that what you're referring to? She says, yeah. We didn't have one at that point. Okay. Boom. Now, why did you become interested in learning the identity of Brian Kober? Not quite sure I understand your question. We were interested in anyone who would have been involved in this. The DNA from the knife sheath. Boom, bitch! Woo! Thank you, Payne. The DNA from the knife sheath. Okay? Then if that's not good enough for people to understand what the fuck Ann Taylor's doing, there's more. Then he says, not sure. The DNA from the knife sheath was obviously the one thing we had. The one thing we had. You had blood. The one thing we had that we thought was, and then here, check this out. Then, I'll back this down. Now, this is straight from now the state's response to the defendant's motion limited to keep the IGG out. As the state has explained as far back as the beginning of litigation over the IGG, and as recently as its competing motion limine filed contemporaneously with the defense's motion, the state does not intend to introduce the IGG information at trial other than to help the jury understand how the investigation progressed. The states can do so by referring to the IGG information as a generic tip without revealing the source or the substance of the tip. An investigator can simply testify that law enforcement received a tip. No, you can't now. And that based on the information received, law enforcement took the next step in the investigation. Conclusion, the state says. The parties do seem to agree, however, that IGG information should not be presented at trial. This court should thus enter an order excluding the IGG information at trial other than as a generic tip for the purposes of helping the jury understand how the investigation progressed? No. Then Ann Taylor responds through Becca Barlow, who's now one of her attorneys, and says, comes now Brian C. Kohlberger by and through his attorney of record and hereby replies to the state's opposition to Mr. Kohlberger's motion limine, exclusion of IGG. The state has agreed. The state has agreed. The state agrees with the outcome of the motion and has agreed to not present any evidence of the IGG process. In its papers, the state says that it can present evidence of a quote unquote generic tip without revealing the source or substance of the tip. Mr. Kohlberger welcomes this argument and asks the state to identify the specific witness who will testify and the testimony that will be given. Now, since this testimony will be quote unquote sanitized for a presentation to the jury to avoid the IGG process, it must also not falsely suggest that there was any other evidence or tip that led the state to Mr. Kohlberger. TK motherfucking O. If you can't see it, I do not feel for you. That's a TKO. It's a TKO because of the whole process to this point. Let it out, girl. Let it out.
And it didn't exist in Brian's car, in Brian's apartment, that there's no other DNA in there other than unknown male B that we know of for sure, and unknown male D outside. There is a lot of context there, and all of a sudden this one thing, the question of how is that there is
the TKO is that you're not going to be able to mention the sheath. You're not going to be able to mention, the state is not going to be able to mention the sheath. If you can't mention the sheath and that Brian Kohlberger's DNA was on the sheath, and how did you figure that out? Because of IGG. You cannot talk about the sheath because you can't talk about the process of IGG, which came from the sheath. And that's how the sheath just got taken the fuck out. It is absolutely brilliant based on the lies. TKO. You are not bringing in, and that's when Becca Barlow says right here, wait, you guys, we already have your lead investigator who said everybody was co-located doing 2 meetings a day, if not more. Everybody's always talking. The name Brian Kohlberger did not come up at any point, any time until December 19th. And how was that, sir? Everybody in the building knew where Brian Kohlberger's name came from. Nobody can get on that stand and say that Brian Kohlberger's name came from any other motherfucking way. And so how are you going to say it to the jury? Sky Game, love it. Make sure you guys donate to Great Use. I fucking love it. I fucking love that comment. Thank you so much. Thank you for my laugh there. Okay. I've been trying to explain this. So what I went ahead and did is I spent literally 3 hours writing this whole thing in the order to show how this all played out, and took different pieces from all the stuff that's been filed, that people have been testifying to. And then now if you back up just a little bit right here, ready? Then I can even use the state's words against them as well when it says that the defense's factual allegations and legal argument all fall flat. But perhaps the most perplexing portion of the defense's motion and the relief requested in the ultimate concession of immateriality, the defense seeks only the exclusion at trial of the IGG information, even though the state has consistently stated it does not plan to present the IGG information to the jury. This means the state finds itself in the unusual position of strongly agreeing with the rationale for the defense's motion, but having no objection to the defense's requested relief. I think that's because you guys are dumb. as the state has explained as far back as the beginning of the litigation over the IGG and as recently as its competing motion to in limine filed contemporaneously with the defense's motion, the state does not intend to introduce the IGG information at trial other than to help the jury understand how the investigation progressed. Oh, you mean like how you tried to help the magistrate with probable cause? Well, if you didn't need to help the magistrate get probable cause, I mean, I'm sure you don't need to do any of the IGG to help the jury understand, right? What is that right? The state can do so by referring to the IGG information as a generic tip without revealing the source or substance of the tip. The fuck you are? There is no tip. There is nothing. There is nothing. And then they even go back here. Ready? Again, the state's words. The IGG was conducted as a preliminary assessment of potential owners of the DNA found on the knife sheath. They own it again in their writing. And Ann Taylor's just like, God, Bicka, you're right. It's working. Everything that you said would work because look at what they're saying. Again, here the state is owning and saying that the IGG was conducted as a preliminary assessment of potential owners of the DNA found on the knife sheath. So what she was trying to get Payne to say, she got him, and then she got the state to say it. And identified the defendant as a potential owner of the DNA. But it was the scientific process of the STR comparison that confirmed defendant's DNA matched the DNA found on the knife sheath. Oh, shit. Woo! Been knowing this since January. Been knowing this since January. It is about to be April Fool's Day. Hoo-hoo. This is what happens when you cheat. This is what happens when you cheat. And now you mix this with Ashley Jennings, knowing that they're like, hey, listen, we won't use the IGG because we got to keep it all hush-hush, how the FBI like totally just used these databases that they weren't supposed to use. So what we'll do is we'll fucking make up that the cast does what it doesn't say it does. And then that's how we'll develop that's how we'll get probable cause. We have to have the phone and the car moving together. And so we're going to say it's doing something that it doesn't do. Way to fucking go, Ashley. You're a fucking moron. You're a criminal. And this ain't her first fucking rodeo. If you think this is the first time that she thought that she would fucking lie, fuck out of here. Crazy. Fuck you, Ashley.
Question that the magistrate should have had. And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true. One of the things that the witness who said these things that couldn't be true also admitted she didn't really know anything. You can't rely on that anymore, so you take that out. You know the identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened.
What woman doing chaos?
And you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Koberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house.
Yeah.
And especially when you know about the lack of DNA connections.
Why wouldn't you?
There's also no connection.
Why wouldn't you? I think about how awesome this is. Why wouldn't you do IGG on the blood? Why wouldn't you have done IGG on the blood? In a stabbing of 4 people all over a house, there's blood on the railing, there's blood on the glove. Why wouldn't you try to see whose blood that was? Right? Did you ever compare the profile on the sheath that you found eventually? Like, did you size that up ever to the blood? Any jury would ask themselves, and if you like, as long as the defense presents it that way, that, hey, does it make sense that you wouldn't try to figure out whose blood was in the house? They were only concerned with what was on a sheet, that they couldn't see this, you couldn't see anything on it. It wasn't like you see a big cum stain on a fucking sheet. You know what I mean? Big saliva, like spit. You have blood on the one side of it. It's a blood mixture. Absolutely crazy.
Between the people in the house and Mr. Koberger, based on their cell phones, based on social media accounts. There's just no connection. The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause. I don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
Well, you're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohlberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of, they're obviously not telling me they found this, and they would have if they did.
I'm not 100% sure I followed. I'm not sure. Are you asking me why I think that's important as far as the Frank's purposes?
Well, for Frank's purposes, you are implying, I think, necessarily that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, etc. Right?
Yes, that's right.
They didn't tell the magistrate that there was evidence. This is a omission.
This is one of the omissions. Yes. Yes, we have false statements and we have omissions both. It's not one thing in this case.
There's understanding complete.
Yeah. Thank you for that. I wasn't following the question the court was asking. I think the other thing, I think I covered all on my proffer, Your Honor. Thank you. Sorry.
Let's go, Jennings.
I think now, Mr. Mayor, are you going to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Your Honor, I think I'm going to cover all of it.
All right, Jennings, baby.
Good afternoon, Your Honor. As you're well aware, you have to make two separate inquiries for each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden.
Girl,
and this is a very high hurdle.
This didn't
for
age
them to
well for
jump
you,
over.
Ashley.
Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation.
Serious.
The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false. That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence or Scrivener's errors or even just negligence. As the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure the probable cause in this case. And the state submits the defendant has failed to back up this claim. And they failed because they can't. Law enforcement.
How bad did this age for Ashley Jennings, ladies and gentlemen? Holy shit. Ashley Jennings did the oral arguing on the fact of lying in these Exhibit A's, in these search warrants. Ashley Jennings did just that. This is unfucking believable. Oh my God, Ashley. Ashley, what are you doing, girl? Shit, you should have been like, Bill, why don't you get up there? I bet you Bill was like, this is why Bill took a back seat. Bill found out about Ashley's shenanigans and was like, I'm going to go play fucking with the band, girl. I got fucking recital tonight. I got practice tonight. You go ahead and start figuring out how you're going to get yourself out of this pickle.
Submitted probable cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked.
Oh my God, Jennings!
The defendant has alleged 13 separate areas where they say there's a Franks violation.
Wait a second.
Various applications were made.
Listen.
That's how it's supposed to work, and that's how it worked.
Wait.
Various applications were made. Law enforcement submitted probable cause affidavits to the magistrate based on the information they had to secure the probable cause in this case.
Wait, listen.
And the state submits the defendant has failed to back up this claim, and they failed because they can't. Law enforcement submitted probable cause affidavits to the magistrate based on the information they had to
the magistrate. I knew it was coming. To the magistrate. Ashley Jennings, I told you she was having some bowel movements when this was going on. To the magistrate. Like, she's just straight bullshit. Sorry, you just had to. She drunk.
They had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A.
You guys.
As the court knows, in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review.
Magistrate!
Essentially the same.
She said it again!
To where we're challenging was about 20 pages of facts for the magistrate to review. Essentially the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne.
Mm-hmm.
Multiple officers were involved in this investigation from multiple agencies.
And so were you.
And they were doing briefings.
And so were you.
Weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information.
The magistrate.
And defendant wants to take issue with this process. But
no, we want to take issue with your goddamn lies. We want to take issue with your lies. You need 10, 15, 30 people to fucking write a document. Hey, okay. We take issue with what's in that shit, B. The fuck out of here. If you need 30 people to be able to be coherent and be able to write a piece of paper, it's for the magistrate, you know? It's for the magistrate to see, you know? You guys, I'm getting a shirt that says, "Hail to the magistrate." Is that courtroom appropriate? Hail to the magistrate. Like, fucking hey, Ashley, goddamn, I can't wait to get this call back and be like, Ashley, have you spoken to the magistrate lately? How does she feel about this?
If the affidavit is attached to Detective A's submission, isn't Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
How about Ashley Jennings?
well,
How does that affect the Frank's analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, the group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there. But that's not what happened.
Wait. Listen to this. This is exactly what happened, you fucking blatant bitch liar. Listen to this shit. That's why that's why the defense is just like this. Like these fucking clowns.
The person that made the statement on the team knows that that statement going into the affidavit, the group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there. But that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly.
Magistrate! You guys, you hear that again.
And if they do so, then I agree. That has to, the court should take issue with that.
Thank you. There you go.
Any office.
You hear? I cannot believe she did this oral arguing. Her ass is so grass. Fucking ass is grass, man. Has she lost her fucking titties? She's lost her fucking mind, man. Like, to get up here. Now, do you understand why Cy Ray wrote the fucking shit he wrote? It's off of the magistrate that she's talking about here.
I'll concede I think there's an issue there.
Good for you. Thank you.
But that's not what happened.
What happened?
I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree. That has to, the court should take issue with that.
That's exactly what she did.
But the cooperative nature of this investigation and this kind of group effort is allowed.
Yeah, it is.
As discussed more extensively in the state's response, we have.
The defense never had issue with your guys' group efforts. Okay? The defense has had issues with your motherfucking lies that then you're using as a group effort. So then who do we put the lie on? Because whose statement is it?
Several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Aldra. And in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening.
Wait,
The
what?
judge was put on notice.
What was she put on notice about?
Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being a.
Do you guys hear her say magistrate every time? It was just me.
Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI S.A. Balance regarding CAST.
Did you?
I consulted with FBI S.A. Hill regarding surveillance footage. It's very clear what the sources of the information were coming from.
Oh, really?
It could absolutely be reasonably inferred where the information was coming from.
Perfect.
The magistrate was not at all misled regarding the sources of all the information. I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges co-worker around King Road residents. And this same claim is in Exhibit A signed by Detective Blaker. Well, this is inaccurate. The officer signing the affidavit did not claim to do the CAS work.
Did you mean AT&T?
Yes. They didn't claim to have gotten those records and put them in to their program to determine the approximate locations of the phone. That was done by Special Agent Balance. And
boom. She just put this on Special Agent Balance. Her bullshit. Her fucking bullshit. She just said that Special Agent Balance did this, okay? And based on what Special Agent Balance did, he told us what it resulted in, and we put it in the affidavit. Well, that's not going to age well for you there, Ashley, and you know it now, don't you?
The affidavit makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience that's involved, SA Balance's own experience. And then the law enforcement officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone.
Yeah, so when they say I was able to determine, who is the I, Ashley? Because just because you consult with an FBI agent I can consult with them and ask them whatever, but then when I come back to write the shit up, because why haven't you gotten any of your Nick Balance expert opinions in? Why haven't you disclosed what his opinion is on where the phone is at 2:54 a.m.? Why hasn't that made its way to the defense yet? You guys had this information in fucking December of 2022, allegedly, supposedly. But we know that, A, you did, but guess what? It's not spitting out what the fuck y'all put on that paper. It does it.
That's not claiming to have done the CSLI work, but instead it's just a reflection. The work was done by Balance. Investigators reviewed that and then made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again.
And that's without and burying the 247 to 254 data that you buried, and then you acted like there's no timing advance, right? I don't know what they're talking about. That doesn't exist. There's no timing advance records. We did not have the defendant's timing advance records. Well, you just got that shit shoved straight up your ass, didn't you? With the magic shit, right? Took a magic shit right there. Ashley Jennings, major shits.
And we're just going to take we have two different opinions about what those records show.
We don't have two different opinions.
We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed.
Yes, they have.
We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area. Defendant is cool.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently? Apart from anything you may have submitted after they filed the Frank's motion.
What specifically?
That there are 3 towers.
I believe
Remember,
I referenced it in my response.
Yeah, but that doesn't. If you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. And so that's why I've been very clear to say I'm looking at what the proffer is from the defense without evidence submitted by the state to determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can move past the number of towers. Here's what is in evidence, though. And based off of the PC affidavit, is that the phone was in the area for the tower that provides service to the 1122 residents.
Is that right?
Still maintain that's true.
Oh, really?
Regardless, none of this has any bearing on the validity of the search warrant. Their argument is merely a clarification about which member did what work. And that doesn't matter to the ultimate determination for probable cause.
Wait a second. Is this bitch insane? That's not what they're saying at all, Ashley. And you know that, but you are trying to gaslight this courtroom. And Cy Ray had enough and just put your ass, instead of you gaslighting, he just lit your ass up, girl. That's what he did. He lit your ass up.
Defendant then makes some allegations regarding an eyewitness statements related to DM. There's kind of 2 buckets of attacks here. The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant. Well,
she said she saw a fucking fireman, Ashley. She said she saw a fireman, okay? She said she was sleeping at 3:20 and 3 o'clock. Between that's when she fell asleep. When you downloaded her fucking phone to know that she was up saving a contact at 3:51, you fucking lying bitch.
It's clear from reading the probable cause affidavit that she's not going to recognize the defendant.
relevance was the statements of DM that were included in the affidavit as to probable cause?
I cited those in my response throughout.
What were they?
Okay.
Yeah.
I can tell you generally, consistently, she gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things?
What's up? Yeah.
In other words, are they going to who the ID of the perpetrator is? Are they going to establish a timeline of when the alleged or when the murders took place? Okay, so it's part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence around the time that corroborates when we know these crimes occurred.
Well,
yes,
we know.
a general description is material and relevant. And that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was.
We're going to call Lisa Mathis's her office and just ask to speak with her paralegal and ask them to leave them a message saying that Truth and Transparency just wants to say, woo, girl! Cowbells. Can we just do that? Let's see. I like to leave a message for Miss Mathis here. Massive. Let's see. Oh, but the balls.
Male, white. She heard a voice that was not someone that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's important. It was that general description. And that general description did not change.
It's also important to establish the timeline.
It is. It's important to establish the timeline to know when the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area.
You don't know that it's a suspect vehicle, though, you idiot.
Leaves, as well as text communications of her relaying what she's observing.
Somebody could have just got the fuck up out of there, and she talked to that person, and then they left, and then I'm like, you a fool.
And even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements.
Wait, exculpatory relevance? You mean, even if something was exculpatory, what? How did she just word that?
Not being included in the probable cause affidavit. You can take all of it out, and the magistrate would still have probable cause.
The magistrate! You guys, that is not going away. The magistrate.
The second issue, defendant, the second kind of bucket that they take issue with DM, is about these other just statements that she gives during their interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well,
A magistrate should know about it.
investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning.
Maybe.
Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong.
Uh-huh.
Next, defendant attacks the vehicle identification. Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed.
Wait a second. This is just simply just not true. I'm sorry, but this is simply just not true. Is not a good explanation there, Ashley. You're going to do better than that. Let's talk about the magistrates. Ready? We got the magistrates.
Picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit.
Of your lies.
The reality is, yeah, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene.
No, you lying cocksucker! Where was it at 358, Ashley? How does it get over there to 1125 Ridge Road? But guess what? Anna didn't even have to argue this shit, girl. You are just dumb. But this is what you do, and this is how you have to argue things when you are wrong, actually. And you don't have it, like, you have to be careful yourself because you know you don't have the nuts.
Which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene. They say, well, that can't be the right video because if it were, then the surveillance right up the street would have also caught this video.
Yeah.
But we know that's not true.
Why?
And that's been submitted to this court.
Wait a second.
They say, well, that can't be the right video because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court.
Wait, how do you know that that's not true? What surveillance are they talking about? Ann Taylor's like saying exactly what I'm saying, which is either it would be on the Paradise 451 or it would be on Ridge coming the other way, and then you have to do some loop-de-loop, go around the other way, but it would take a long time, 8 minutes. Or what Ann Taylor's really suggesting here is that the surveillance camera at Lane would have it coming on Taylor. Okay? So what the fuck are you talking about, Ashley? What do you mean? We know it's not true. What are you talking about? What do you mean you know it's not true? Linda Lane is running nonstop. You are a fucking liar. And your fucking tits are getting squashed to oblivion. That's what's happening right now. I would swallow my pride. I would jump on the line. Turn inside out, find nothing but
this video. But we know that's not true. And that's been submitted to this court.
What?
Excuse me?
When?
When?
Was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
It was submitted through my response that their logic is flawed.
Why?
And I can tell you, it has since been confirmed. I do not have, and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again.
Oh my God. Are you talking about the fucking 451? You're trying to say it went that way? Oh my God. She's saying that the car did not go Taylor. Holy shit. You guys hear this? Criminality. You need to hear this right here. This is everything. Ashley Jennings is saying that this vehicle did not go Taylor and that it came like around and down, like to go Walenta to then get to Ridge. Well, that bitch has no idea. Then boom, boom, and boom, because you cannot do any of that without hijacking over and flying over medians that would have fucked your car up on 2 different streets. Fuck you, Ashley. You're a liar, dude. This is sick.
It doesn't matter. At the end of the day,
What?
The defendant's speculation about the route of travel.
Wait.
And their differing opinions.
Wait a second. The defendant's speculation of the route of travel, it's your burden. The defendant doesn't have to talk about shit about this. You're to tell the jury, like, how do you think this happened? How is it 3 in the morning and 58 seconds, or 3 hours, 58 minutes, about to be 4 o'clock, this vehicle that leaves, how is it coming back and being the 401 that's over on Ridge Road? And then from that, how is it then the 404? Are you fucking insane? Ashley, this bitch doesn't think it matters, just like Nick McLeland doesn't think shit matters. The way that she just says it, well, none of that matters. Then why wouldn't you just start at 401 or 404 rather? Fuck 401. Why wouldn't you just start at 404? Because you're just right there. You're saying it's not relevant. So you're not going to use any surveillance cameras except for the 404 one. When it comes into the fucking camera for the 1122 area. This is insane.
Opinion on it isn't it doesn't matter. At the end of the day,
What?
The defendant's speculation about the route of travel and their differing opinion on it isn't the basis for a Franks hearing. There's no legal basis for second guessing a vehicle specialist's opinion.
What? He didn't.
And they haven't made a substantial.
His opinion isn't on the 1112 camera, you fucking bitch, and you know it. And you're telling the magistrate that the fucking emo dude said, yeah, oh yep, he made his identification off of the 1125 Ridge Road camera at 4:01 a.m. It is your job to show the jury that the 401 car first of all, is Brian Goldberger's, which you can't. And where the fuck did it come from? Where did the 401 car come from? Where it just plops down on Ridge Road? Right next to Cole's house, your number one suspect, where he lived in those apartments right there. Coming from Ridge Road, how it came down south to East Lauder. Guess what, Ashley? That's coming straight from the fucking frats. And you know it. And I know it. It's coming straight down across from Taylor, up over there off Nez Pierce, isn't it? That's how you get up over there. It's fine, though. Run your game, girl. You damn lie.
Or sufficient proffer for you to do that.
Proffer? You know what? You're right. But Cy Ray just gave a sufficient proffer, huh? You sick girl. 47 years old, acting like you're 22.
Next, the briefing addresses the IGG issue. And
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether the affidavit describes the specific shots and cameras relied upon to make the identification.
No.
Thank you.
It discusses that
Did you just hear her?
several.
You heard what you just said there, right? Very simple question. Ashley, did the probable cause explain what cameras were relied upon? She said no. Here we go.
Describes the specific shots and cameras relied upon to make the identification.
No. It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate. No.
To the
Nor
magistrate.
did we need to.
Nor did we need to. But guess what? You're right, Ashley. You're going to have to do it for fucking the goddamn case. How do you plan on? No, we didn't have to do that. Nor did we have to. Ashley, that's where you're so fucking wrong. You are so wrong. And you know that you're wrong when you say that. Your probable cause is shit. But guess what? Use your probable cause and try to go get a conviction. Because it's never happening. Only way you're getting your ass out of this is if Hitler decides to put you on his little fucking old back and carry your fat fucking ass out of there. Hitler will have to fucking take one on his back for you.
Really, the IGG has been discussed extensively. I think the only real Frank's issue is, should the IGG process, the fact that it was not included in the PC, is that the basis for a Frank's hearing?
What?
But you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it. They were told it's only a tip and that they should develop probable cause separately. And that's what they did.
Wait, exactly.
And at the end of the day,
Wait, it's so good with what you just said there, Ashley. And they made a strategic decision to do it not through IGG and to do it this other way, which was you fabricating and finding yourself in the fucking hole that you're in right now. You understand that? So one would have to ask themselves, why the fuck would you ever risk your career to do this, Ashley? And in fact, when you saw that you couldn't connect the dots with the car, why didn't you just go tell, hey, guess what, feds? We have no choice but to use IGG here because we can't connect him with the car because the car has him going this other fucking way. The car has him in another state, the phone, and we can't, or we can just lie. And you chose to lie, why would you fucking do that? Only a person that is fucking stupid would have to ask you why you lied. If it's shit, it looks like shit, smells like shit, it is shit. I don't care why. Give a fuck why. Why'd you lie? Because you're shit. You look like shit, you smell like shit, you're shit.
Honor's already
Magic shit. Imagine shit.
the nail on the head through your questioning of Miss Taylor. At the end of the day, this information regarding IgG and the use of IgG is only inculpatory. And the non-reliance on the IgG information does not diminish probable cause. And the IgG information was confirmed through the STR testing. I can't wrap my head around any argument that IgG and STR testing would be exculpatory.
Who is saying that it is? What the fuck are you talking about? Who out there is saying that would be exculpatory? That's not what anybody is saying. Maybe that's why you can't wrap your fucking head around it, Ashley. Nobody is saying that. What is this girl smoking, you know? Her husband's got to be so proud.
Defendant makes kind of hay about the dog barking. And that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes. And this is just a reach for me.
It's a reach around for me, girl, too. I'm trying to reach around, get you some play, baby. What is going? It's a reach for me. Why would they care about a dog barking for 25 minutes straight afterwards? Like what? Like that means anything. Well, I don't know. Your investigators decided to go in there and do some dog test and bark. So I don't know. You guys clearly thought it was relevant. Magistrates. The magistrates in Latah County are just fucking like, why did she call us magistrates? God, Ashley, we don't do that shitty of a job. We got the magistrates coming through here, though. You guys, I can't breathe.
It's still unclear how this is exculpatory. And again, this fact just doesn't.
Because they told you, the girls told you that they went to sleep, okay? They never told you that they had to go outside and get Murphy, right? Why is this dog out there barking? And then Hitler just answers for her.
Not diminished. Take out all information related to the dog.
Okay.
It doesn't
The magistrates.
diminish probable cause.
What?
Circling back to the cell phones. At the end of the day,
Cell phones.
this is the proffer is their opinion of the evidence. That's not the basis for a Frank's hearing. We're relying on our expert's opinion. They disagree. And that is a dispute that should be had, and it should be had at trial. And I suspect.
And so you want to put a motion in limine for the AT&T fucking timing advance, didn't you, little scared bitch? Didn't you? That should be something at trial. No. Then you go ahead and file a fucking motion in limine to keep the fucking AT&T timing advanced out. Why, Ashley? And then Cyree was like, enough. Now I've heard enough. This is blatant lies by the prosecution that I've never seen in all my years of doing this. And all I do is work with prosecutors. You just heard her say that. That should be handled at trial. She just tried to keep it out of trial with her motion in limine. At the end of the day, Ashley, you have mega shits.
It will. But it doesn't give you the basis to grant a Frank's hearing.
Grant a Frank's. Oh, okay, mega shits.
Defendant next, the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material.
Well, wouldn't you wonder who in there is only one-legged, Ashley? Would you ever think to yourself, who on campus only has one leg? How is there only one footprint? Last time I checked, I would be like, wait a second, why is there only one footprint? Where's this other footprint at? Did somebody try to clean up the other footprint? There's one footprint, there's one brow, and there's one magic shit.
They let the judge know that it was outside the door to DM's bedroom located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation. Defendants' opinions about where the shoe print should have been located and it couldn't necessarily have been located there. Again, that just doesn't rise to the level to warrant a Frank's hearing.
You lying! It's lies!
Again, our case doesn't hinge on the identification of the shoe print. Neither did the PC affidavit.
PC my
There
ass.
was sufficient probable cause with or without this information. I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their motion.
Yes, before you get to that, can you address the allegation that the cell phone data was, I guess, purposefully erroneous as to the time that the phone was no longer?
That's when Bill Jennings has a heart attack when he hears that. Can you talk about this? Bill Jennings just loses it. You guys right there, you heard the coughing attack by Bill. Bill has a complete coughing attack there. Oh my God, he just loses it, okay? Loses it.
Reporting, which then relates to the supposed position of travel.
Right. Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't
I
understand.
understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By Detective Payne? Or by the
The
cast member?
information that he was given from.
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the cast special.
Listen, guys, we have her tell. Ashley Jennings' tell is when she does this little laugh. When she's lying, she does this I don't think you have before you a proper proffer to say that dude, this is her, because we know now she's lying. She actually knew. Ashley Jennings knew herself, okay, that what was put in the probable cause affidavit was erroneous. Duping delight.
Submitted false information.
Okay, hold on. Wait, hold on.
Apparently there's a difference in the handoffs of 7 minutes. At the end, I don't think that you have before you a sufficient proffer that proves that the cast specialist submitted false information. Apparently there's a difference in the handoffs of 7 minutes. At the end of the day, okay. No, I don't think it's incredibly material.
Is it material if you look at it in terms of where the phone was in that 7 minutes?
Well, it's material.
Going a direction different than what your affidavit says it was going. Isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman.
She doesn't know where it's reporting to a tower, because remember they said that it shut off at 2:47, so she wouldn't know where it was reporting. Okay, this is where she is so fucked. She is so fucked.
I mean, this assumption assumes that cars can't change direction of travel.
Just like your fucking white Honda Elantra, right?
We're assuming that.
And guess what? You don't have to assume anymore, Ashley, right? Because we have the 247 to 254 time frame, like you all had in the beginning, right? Is that right? That you buried. There's no assuming that a car turned around. You had the evidence. You buried the evidence from 247 until 254 in your probable cause affidavit. But you had it. So you gotta stop saying this. Well, it's what we had at the time. It's what we had at the time. Nah, bitch. You had this at the time. And now your ass is straight motherfucking grass. Because if Hitler allows this is when he puts his hand over his head and you're done. Okay? And how Hitler saw it is this. Are these things merited for like the Franks? Because I'm going to go off of what this prosecutor is saying, that she's not straight up just standing up here lying to me, right? Well, then she goes and makes a motion to eliminate talking about the timing advanced. The same very thing that she just said 10 minutes ago, that's for trial. We can talk about that at trial. She tries to keep out at trial. And then somebody had enough of it and filed 2 huge affidavits.
Then the same cell phone, which was then turned off.
No. Where is there evidence that it was turned off?
Isn't then also tied to the evidence where we do have information to believe a white sedan tied to Mr. Koberger is then found on surveillance. We're not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning which is about an hour, approximately a little over an hour before the crimes occurred.
Yeah, but you have them on surveillance at 3:26, you dumb broad. And that's why you've tried to walk all that shit back in your little fucking back and forth filings. Ashley, you done. And you totally did not. Then you skated away from it and you're talking about that car doesn't tie to Mr. Kohlberger. There's no license plate on it. Are you dumb?
I don't follow the logic that this 7 minutes, an hour and 10 minutes prior proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction.
What are you just saying right there? Whether he couldn't? You're the one now that's speculating. Do you fucking hear this woman's arguments? And all the defense did was read exactly how Hitler worded it to know then exactly how to attack everything moving forward. This sheath is out. They will not be talking about Brian Kober's DNA at the crime scene. And if they are able to do that, this will be 100% appealable for days because there is no tip that brings you to Brian Kober without using IgG. Nothing. And it has been testified to under the penalties of perjury. And it's been written in motions by the prosecutors. It's curtains. The piece of evidence they specifically got them to say was the knife sheath, and that's what the IgG was used on the knife sheath. There is no talking about that. So then how do you mention Brian's DNA and where it came from?
Your Honor, our position is that the court should suppress the IgG identification and everything that flows from that. This is supported by Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution.
And so all Ann Taylor did was that if you're not going to suppress it due to these reasons, then we're gonna suppress it this way. And that's exactly what they've done. I love the shit out of all of you people. Okay. I agree, Jody and everybody else who's been saying it. At the end of the day, now, can you imagine that this is the prosecution's face of this case? Ashley Jennings is the face of the prosecution's case in one of the biggest cases that the United States has had. Like, name me the last case that's actually gone to trial that's been an actual, like, whodunit. Whodunit. Name me a case where somebody that they eventually would get like this quote unquote confession or some crazy shit like that, you know, because that's what happened in the Delphi case. The Delphi case was the last case that had like a whodunit type of thing. But then they were able to get that man to make all these crazy confessions, right? You don't have anything like that in this case. This case was poorly investigated or purposely poorly investigated. Okay. I've had the pleasure of knowing and seeing exactly how Idaho State Police works. And they were involved in this. Okay. And then the local law enforcement people from other areas in Idaho and how they operate. And they are not good at their jobs. And you can ask yourselves if you think it's because of incompetency, they weren't trained well, or if it's for other reasons. And to think that Ashley Jennings is going to be the representation of those victims, that sucks for them. That royally fucking sucks. Because those victims and their families deserve better than Ashley fucking Jennings. Peace out. I'll be back on later. I'm going to be changing actually the title of the live because we're going to show Steve's latest interview. And oh, thank you so much there, Lindsay. $50. Oh my God. We love all the work that you do, TNT. Thank you so much, Lindsay. That was so kind. And everybody else that's been super chatting. Thank you, Storm Dancer. Wasn't Daddy Green involved in those twice a day meetings? We'll see. So the state tried to downplay the sheets to get to the defense to ignore fighting it. They say that they aren't going to be mentioning the IgG through a tip, so then the tip's allowed to be mentioned during trial. Yeah, it's basically the defense did such a great job to say, because they knew that there's nothing that is linking Brian Kober to this other than that? And it's like, why aren't you? There's been so many cases that use IGG that talk about it. Why wouldn't they just be doing the same thing? And people say, well, they're just going to talk about that it was an investigative generic tip. And I said, yeah, that works in other things when you're announcing that you're using it at some point. So then instead of just like going into all about people just say, hey, for the purposes of not confusing the jury and stuff, like we can just say it was an investigative lead or whatever. But in this type of a situation, you have somebody saying like, no, because you never disclosed that's how you ever got to Brian Kober. You went these routes. I've told this to law enforcement that I've talked to for a long time. I said, this isn't like those cases, watch. And this is how it's different. And Ann Taylor has them on the record saying that they did not get to Brian Kober any other way than investigative genetic genealogy. So then how? And then Becca Barlow says, if you think that you're going to lie to the jury to try to say that you got to them some other type of way, go ahead, guys. Use your probable cause affidavit. Let's see how well that works out. And they know that it's not going to work out because it's lies. That's why they're over there begging for them to use a generic tip. And it's like, that's not happening because you're not lying to the jury. It's one thing to suppress evidence that a jury doesn't see. It's another thing that you manufacture fake evidence to tell a jury how you got this generic tip on December 19th. That's not happening. Mark my words, that's not happening. Everything that flows from IGG is out. Use your probable cause affidavit, like how you told the magistrate you got to him. Go ahead, use it. Think about it. Sit back and think about it. Go for a walk or a run and think about if you were a prosecutor, how are you going to be able to tell the story, the narrative with your witnesses and tell the jury how you got to Brian Kober and why you ever would have went and got his parents' trash in Pennsylvania to test it against a knife sheath? How do you do that? You can't. You can't. So we're all going to play prosecutor here, and I'm going to do the best job I possibly can to be the prosecutor in that position, but there's just nothing there. You'd have to lie to the jury, or you'd have to have used the IGG. And there's no fruits anywhere. Like how Hitler tried to put it in these orders that you can't say that they didn't get to them partially because of the plate and partially because of Washington State. It's like, dude, you have no idea about this case, do you? Because you're not reading the documents that are coming in. And that's nothing that Cyree wrote. These aren't misunderstandings like Ashley Jennings is saying. These aren't squabbles or squibbles or magistrates. This is blatant lies. Much love. Much love. Amy K, welcome. New member. Woohoo! As far as my opinion on the motive for, I think we just look, it's right. It's kind of like Occam's razor. If you believe the families and you believe these surviving witnesses, they all played pranks on each other all the time. They all had knives and shit like that. You mix drugs and you mix things together and fucking crazy shit happens. Go watch the new Netflix binge right now. It's 6 episodes. It's awesome. It's called Caught. There's a balaclava in it, and they make this guy put it on, and this girl knows that that's who raped her just by the eyebrows. So when Dylan Mortensen saw, in my opinion, Brian and would have saw those eyes, and like you don't forget that shit, depending on how long you actually saw the dude or if that's even the guy. But it's actually a really good 6-part. Go watch it. It's called Caught on Netflix. You'll watch it all. It'll take you about, I like baklava better too. Caught, Netflix. I just watched it all yesterday. I was enjoying my relaxing Sunday. I had to mute Ashley. I can't listen to her. But I wanted you guys to hear Ashley again, because now it just go back and you're going to see where this is all going. And that it's Ashley's words, and she just lied and lied and lied and lied and lied. She's been lying. She's been the one that's been doing it all since November 15th. She's been the detective, the prosecutor. And if I was these parents of these victims, I would fucking have her like I'd be speed down. Ashley, what the fuck is going on? What am I reading about? Ashley, what's going on? You know what I mean? Like, everybody would have known that nobody slept through that, what was going on, right? Nobody slept through it, right? Well, those girls didn't sleep through it, right? They were awake. They were there. You got to figure out why they weren't killed. That would be a big part of the investigation in the beginning, wouldn't it? Victimology. Anybody's going to say no is a fool. Peace out. $3 billion a year is a motive. No. They picked money. They picked money at Idaho, with the University of Idaho, over doing this investigation the right way. And that's unfortunate. They didn't want bad publicity. The Greek life, they didn't want any of that shit. All I know is you got people that are supposedly witnesses, and they're lying to the police. They're lying about what time they went to bed. They're lying about what they were doing at 3:51 in the morning. We have a DoorDasher that came there. We're missing the Linda Lane footage, and Ashley Jennings wants to put a magical car driving all around, and poof, that's just Brian Koberger's car. These are the type of cases that prosecutors will tell you. Prosecutors will tell you, we don't have enough. You need to get X, Y, and Z, you know? Well, here, when your prosecutor is also the detective, like, they brought this case forward. Bill Thompson and Ashley Jennings. That's why Payne and Mowry, I don't know. I don't remember. You know what? They ain't lying, because they weren't the ones doing it. Peace out. Peace out.